They've stood at the front lines of law, leadership, and public service. From the courtroom to the classroom, Attorney Karen Jimeno brings sharp legal insight, academic excellence, and a voice that has guided national conversations. Attorney Mike Toledo, a seasoned public affairs strategist and legal mind with years in media, corporate leadership, and government reform. Together, they bring law to life with experience, integrity, and the courage to ask hard questions. Two minds shaped by the law. Two voices trusted in and out of the courtroom. This is ABOGADO.
Good evening and welcome to ABOGADO, where we delve into the core of laws and court decisions as leading legal minds dissect the pressing issues shaping our nation. I'm Attorney Mike Toledo.
And I'm Attorney Karen Jimeno. Tonight, we confront a question of immense weight, one that cuts to the very core of our constitutional framework. Here's the fundamental question that demands our attention.
An impeachment stopped by the Supreme Court. In a landmark decision, the court ruled that the impeachment of Vice President Sara Duterte was invalid, citing a new definition of when the process is initiated. Supporters call it a defense of procedure and stability. Critics warn it's a dangerous overreach, shutting down the people's right to demand accountability. Did the court clarify the rules or create new ones? Did it preserve checks and balances or weaken democratic accountability? As we weigh procedure against principle and power against oversight, we ask, did the Supreme Court ruling strengthen constitutional safeguards or suppress democratic accountability?
Taking on tonight's challenging legal question is one of the country's most respected legal minds, retired Supreme Court Senior Associate Justice Antonio Carpio, a former Chief Presidential Legal Counsel under President Fidel Ramos. Justice Carpio is widely recognized for his unwavering commitment to constitutional law and national sovereignty.
Justice Carpio graduated valedictorian and cum laude from the University of the Philippines College of Law and has often been called the best Chief Justice we never had, and I totally agree. Definitely a testament to his integrity and intellect. And if I may say, partner, I'm just so glad because Senior Justice Tony Carpio was my professor in the UP College of Law. He taught us corporate law, and because of that, I did well in corporate law. Thank you so much, Justice.
Lucky you.
Yeah, and by the way, he gave me a nice grade too.
Oh, okay. So you were a smart student. For me naman, I look up to Justice Carpio, of course, for your track record, but he was also batch 74
Yes.
in UP Law, like my dad. So, Justice, let's start first with the Supreme Court's decision on the impeachment complaint. What was your initial reaction to the Supreme Court's decision declaring the fourth impeachment complaint as against Vice President Sara Duterte to be null and void and violating the one-year bar rule?
Well, it was a total surprise for me and my friends because the ground was supposed to be a violation of the one-year bar rule. But per our count, there was no violation because the plenary actually voted to adopt the resolution signed by 215 congressmen. That's more than one-third. And they voted to authorize the Secretary General, Velasco, to transmit the articles of impeachment to the House. And it arrived in the House about almost 5 o'clock in the afternoon of February 25. And the House adjourned at 7:15 p.m. So before adjournment, the fourth complaint was already voted upon by the plenary and sent to the Senate. The Senate received the articles of impeachment, And thereafter, after 2 hours, the House adjourned. The Supreme Court said that upon adjournment of the House, the 1-year ban took effect, started to run. So, pasok yung the articles of impeachment were filed on time, the fourth one. No? And there's a statement there in the decision, in the resolution of the Supreme Court, that the articles of impeachment were not voted upon by the plenary. It was transmitted even without a vote by the plenary, which is totally inconsistent with the records of the House. And that's precisely one of the grounds that the House also mentioned that they will use in their motion for reconsideration.
Were you surprised that it was unanimous?
Yeah, I was surprised. But if you base it on the fact that they said that there was no vote, then I wouldn't be surprised, no? If their facts were correct. But their facts were not correct. And secondly, the second ground that we have to consider is the one that was raised by Justice Ascuna, that there is this doctrine of operative fact, that if an old doctrine, prior doctrine is reversed, is abandoned by the court, the new doctrine will be applied prospectively. Will not apply to the present case because when the court decided on that case under the doctrine at that time, there was no other doctrine but that doctrine. They actually complied with existing doctrine.
That is why Justice Acuna mentioned, partner, that it may be legal but unfair because and the doctrine of operative facts should be applied here because precisely they relied on the Supreme Court decision in the past. Hence, that's why they acted that way. But of course, the court ruled otherwise. But,
you mean acted that way in terms of not referring the 3 impeachment complaints to the Committee of Justice?
Yes, they were saying that, in other words, they in effect amended what was done in the past by the Supreme Court. And that is why they were saying the doctrine of operative facts should apply so that and it cannot be, it should be applied only prospectively as Justice Tony mentioned.
The theory behind that is to comply with due process. If the court will say you violated the law must be existing at the time.
Correct.
And you must have knowledge, either constructively or actually. Constructively because it forms part of the law of the land and you are deemed to know it. But in this case, there was no rule at that time that at the plenary level, the House will have to hold a hearing. Give notice to the person being impeached, and then ask for his or her comment, and then schedule a hearing. They have only 3 session days from the time that it's included in the order of business. The plenary must transmit it to the Committee on Justice within 3 session days. It's physically impossible to hold a hearing.
So in your view, Justice, there was no violation of due process here because in the decision, they said they had to rule it as constitutional, partner, for 2 reasons. One, it violated the 1-year prohibition. And number 2, there was allegedly a violation of due process against the Vice President as enshrined in the Bill of Rights. What is your view on that? Was there a violation of due process? As I recall my law, due process is substantial and procedural, the right to be heard, essentially. So was there really a violation? And if there was none, why?
There was no violation because first, the right to be heard, the right to present your side is at the committee level. There was, at the plenary level, the plenary of Congress does not hold hearings, investigative hearings. They operate by committees, unless the plenary is declared as a committee of the whole. It's like the prosecutor. When there is a complaint, the prosecutor decides, I will refer this to this investigating prosecutor. At that point, the person being complained of has no right to be heard. He will be heard by the investigating prosecutor.
Yes.
The plenary is like the chief prosecutor.
Yes.
You don't you don't present your evidence there, you don't argue with him. Because what he does is decide to whom do I refer this. And that's exactly the plenary. They referred it to the proper committee. And the proper committee is the Committee on Justice. And that's where they will be heard.
But that's with respect to initiating an impeachment complaint under Article 11, Section 3, Paragraph 2.
Yeah, that's the first mode.
Yes.
Yeah, but in the second mode, it says
By a vote of one.
once the articles of impeachment are signed by at least one-third of the members of the House.
And in this
ito
case,
yun.
it was more.
Yeah.
Well, it's 215.
Yeah.
The Constitution expressly says once it's signed, the same, the articles of impeachment, the same shall constitute the articles of impeachment, and trial by the Senate shall proceed forthwith. So there is no
Requirement to hear it. in
there's
a-
no time because forthwith has been defined in the Filipino version, official version of the Constitution. Forthwith is translated as agad-agad. So, and trial by the Senate shall proceed agad-agad. So there is no time to conduct a hearing. And besides, if you file it on the 10th day, 10th session day, the last day, that's still allowed because the House is given 10 session days.
Yes, not calendar
Yeah,
days.
if the complaint is filed on the 10th day, taken up on the 10th day, then you don't have a time to hear it. Because to hear it, it will take more than 3 session days. So you have to act on it, throw it to either to the committee. In fact, in the first mode, there are 2 dates there.
Yes,
the 10
session days.
The speaker must
Yeah.
include it in the order of business within 10 session days.
Yes.
And after it's included, the plenary has to refer it to the proper committee within 3 session days.
Yeah.
But in the second mode, there are no days mentioned because the word uses forthwith, agad-agad. So you don't wait for any, agad-agad. That's why in this case, once they approved it, the plenary here approved it at 3:37 p.m. of February 5. They sent it right away and was received by the Senate at 4:57 or 4:59, almost 5 o'clock. So agad-agad, dinala nila.
But Justice Carpio, I seem to remember in the decision of the Supreme Court that the due process issue relating to the 4th impeachment complaint was that a copy of the impeachment complaint was not provided to the respondent, Vice President Sara Duterte. So she was deprived of the opportunity to be heard. And to waive that right is up to her.
This is how it goes. Because once the articles of impeachment are signed by one-third, agad-agad they'll bring it to the Senate. And it is the Senate that will issue the summons. And in the summons, and this happened, the summons, attached to the summons were the articles. Because katulad nga ng chief prosecutor, you don't appear. He does not notify you. It's the investigating prosecutor that will notify you. So, because the committee, the plenary as a whole does not really conduct these investigations. The investigations are conducted by the committees, unless the plenary is declared a committee of the whole. No? So, there is no time frame. No date is mentioned in the second mode because agad-agad bring it to the Senate, and this is exactly what they did.
Yep. Justice, the court, in its decision, partner, emphasized that impeachment is a legal process subject to judicial review and not just purely political. Do you agree with that kind of view?
Well, basically, the court said that it's a legal process, but also political. So it's really hybrid. That has been the traditional view. It's first of all, it's not.
It's a sui generis.
Yeah.
diba?
Yeah, sui generis. It's one of a kind, and that's why there's a different procedure. In fact, to convict, it's very high, not 2/3. But before, in the old constitution, it was even higher, 3/4. So it's one of a kind, and you cannot avoid it. All the judges are politicos, they have been elected to public office. So it's one of a kind. So it's not purely legal, it's not purely judicial, but you have it's a hybrid. I would say it's a hybrid.
Well, Justice Tony, I want to go back to the Article 11, Section 3, Paragraph 2, that mode of the impeachment where there were 3 impeachment complaints that were not acted upon by Congress. And this is where the Supreme Court, it seems, found grave abuse of discretion because they said that the Secretary General and the Speaker should have no discretion to not act upon the impeachment complaint. And they applied the verba legis doctrine to say that the wording of the Constitution says that upon the receipt of an impeachment complaint, they should include it in the order of business within 10 session days and then refer it to the Committee on Justice within 3 session days, and that should have been followed. And therefore, in this case, when they did not act upon those impeachment complaints within that timeline, then the time that the Congress adjourned was deemed a dismissal. What do you say about that line of reasoning?
Well, first of all, the House submitted its reply, and they tabulated there the first complaint, second complaint, third complaint. They were all taken up on the 10th session day. So there was no violation of a 10th session day. In fact, everything happened on the 10th session day, and I am told by the lawyers of the House that they were conscious of the 10 session days. And of course, it's different from calendar days. So on the 10th session day, the first thing they did was to submit the resolution signed by 215 members, submitted it to the Secretary General, because that's what the House rules state, that you must submit the resolution signed by at least 1/3 to the Secretary General. And the Secretary General included it in the order of business of that day. And at 3:57 in the afternoon, a motion was made by Congressman Dalipe moving to send that this was signed already by 215, and this now must be sent to the Senate. And they voted, and there was no objection. It was a unanimous vote. So 2 hours later, the Senate received it. Agad-agad. They followed it to the letter.
This relates to the 3 impeachment complaints, or the 4?
No, that is the 4th. Because after they voted on to send the 4th to the Senate, there was another motion to archive the 3, because the 3 became functus officio. Because what prevailed now was the 4th.
Yes.
Because the Constitution says the same shall constitute the articles of impeachment. So the 3 were superseded. In fact, the history of the 4th is this. The 4th was a composite of the first three. They got the best arguments, the best allegations in the 1st, 2nd, and 3rd, and put it in the 4th and added. That's why there was no use anymore for the... And in fact, the congressman who endorsed the 1st, 2nd, and 3rd all endorsed the 4th. They really said, this is the composite, this is the combination of the 3rd.
Was it right for the court?
So is there a discretion there for Congress to choose a 4th complaint and wait for a 4th complaint and not act upon the 3?
In Chavez, in Francisco versus House of Representatives, the court said the plenary can combine, can wait for all before the 10th session day and send it at the same time, or they can combine and have their own. And that's exactly what they did.
So it's not prohibited by the Constitution?
Yeah, it's in fact allowed under the Francisco ruling.
Yeah, I remember the Francisco ruling, partner. They define what being initiated means.
Initiated means...
It was very clear in the Francisco ruling.
I think at that ruling, it's upon referral to the Committee on
the
Justice.
filing and referral to the Committee on Justice.
Yeah.
But there's a twist here. In the present decision, it was not referred to the Committee on Justice. In fact, it was archived.
Yes.
And the court said that's equivalent to dismissal.
Yeah.
But they said, since it was dismissed, the 1-year bar period began to
Yes,
run.
applies to those first three. So parang hiniwalay kasi nila.
But is that correct, partner?
Yeah.
That always hounds me. is the mere archiving of a case tantamount to a dismissal?
Well, my understanding from the Supreme Court decision is that it's tantamount to a dismissal because they should have acted in accordance with the Constitution, where it prescribes the days, the session days within which they should have put it in the calendar or in the order of business and then referred it to the Committee on Justice, which did not happen in this case.
Yeah, but in Francisco, the court said that once there is the articles are signed by at least 1/3, that supersedes, provided it is done within the 10th session day. In Francisco, the articles that was signed by 1/3 of the members was submitted after the 10th session day. That's why it was the court said that's too late. So once there is, because it's natural. It's just logical that there were 3 complaints signed by by private persons and endorsed by congressmen, and the 4th came in, signed by at least 1/3. The Constitution says the same shall constitute the articles of impeachment.
Yes.
That means the other 3 are superseded. They become functus officio. It can't be used for anything anymore. That's why the House archived it. And the Supreme Court said, oh, it's archived, it's considered dismissed, and the 1-year bar period applies. Now, the problem here is the 1-year bar period, the reason for that is because you have been subjected to impeachment, it has reached the Committee on Justice, you are now defending yourself, you have to get lawyers, you have to answer, you have to be there. That is already inconvenience, and if you add one more, that will be harassment. That's why there is a bar. But if it is dismissed, that doesn't happen. There are no proceedings. It's totally ended. Why will you apply the 1-year bar rule when the reason for the 1-year bar rule is to prevent additional complaints because you already have an existing complaint to defend against?
Just as a side question in relation to that, partner, isn't it also sometimes the strategy of somebody that is going to be impeached? But it's like having a company union, similar. I don't know if that really applies, but it's like, okay, there's a strong move for me to be impeached. So I'm going to ask a friend of mine in Congress to file an impeachment case which actually does not hold any water, but enough to make it the 1-year ban applicable. Is that
That's
exactly
na sham complaint. But in this case, it didn't seem like it was a sham complaint, no?
Here, exactly, since it's not frivolous, but there seems to be a semblance of a legitimacy. But let us say the plenary says, oh, this is not worth it, so we will dismiss it. Now, for 1 year, nobody can file a complaint.
Correct. Yes.
So he has immunized himself.
Exactly.
But the harassment situation will not be there because if it's dismissed anyway, you are not put to prejudice. You do not have to defend yourself at the Committee on Justice. So why do you immunize him? There is no harassment. He's not inconvenienced.
Okay.
The 1-year bar is to prevent you from being additionally inconvenienced. You can only be inconvenienced once in one case. But here, there is none. Okay. So why do you impose the 1-year bar? That's why I said, if the plenary will refer it to the en banc, you will face the en banc, it's referred to the Committee on Justice, you have to be there, defend yourself, present your evidence. That's a lot of inconvenience. So that's why nobody else can file another case against you. But here, when it is dismissed, you are not put at risk. Why do you apply the 1-year bar rule?
Correct.
Well, Justice Tony, what about the other side of the argument? Some argue that allowing Congress to freeze endorsed complaints could also be a loophole that was not intended by our Constitution. So in this case, there was also no explanation from Congress why they didn't act on the first 3 impeachment complaints.
No, remember, the plenary has 10 session days to act. If they act on the first day, well and good. But if they act on the 10th day, they are within their rights. There is no default. They have not violated anything. And that's exactly what they did. They acted on the 10th day, so they acted within the period allowed.
So you're saying the action that they took was to initiate the other mode, the second mode of
Yes, because
filing an impeachment
under
complaint, which is the
Francisco,
1/3 vote.
The plenary is allowed to combine, to get the best elements of the previous complaints and put up one good one, complaint that's good, very strong, and that's exactly what they did. So you cannot fault them. They followed Francisco.
You know, that's why sometimes, Justice, I guess there are a lot of views that we've been hearing now from a lot of legal and even political pundits are really saying, and I, for that matter, I'm of the view, I mean, the Constitution is quite clear. A statutory construction says if there is no ambiguity, then you follow the strict letter of the law. Ganun na kasimple, di ba, partner? Klaro naman dito. It adopted the second mode, wherein then you got more than the 1/3 requirement na nakalagay sa ating saligang batas. In fact, it was one by 215. And then per the Constitution, it shall be, the articles of impeachment shall be transmitted to the Senate and trial shall forthwith commence.
Yeah. But I guess
So,
I will.
very clear.
I will act
bakit
as a,
nagkaroon na- yeah,
so I will try to
partner,
justify the Supreme Court
bakit?
decision's ruling based on my reading of it. They separated the second mode of impeachment from the first three. Because the first three, according to Article 11, Section 3, Paragraph 2, has mandated periods within which Congress should have acted upon it, which was not followed according to the Supreme Court. And therefore, they said that because it was archived, not acted upon, then it was considered dismissed on February, I think it was
But
5.
they also say that that's not accurate in terms
that's
of the
not
fact.
accurate because it was acted upon on the 10th day.
Yeah. So I think
10th
that's
day.
where the difference in
Yes.
interpretation
Yeah,
is na yung naging second mode was acting on the first three.
In fact, the Supreme Court said they properly disposed of the three because they acted within the 10th day. But it's still void because the fourth complaint was not voted upon by the plenary. That was the reason. It was not the...
And it's not the violation of the one-year bar rule. That's why
No, because
understanding.
Because it was not voted upon the plenary, then it was not acted upon within the 10 session days. You cannot act on it now because the one-year bar rule started when the Congress adjourned.
Yeah.
So first there was a mistake. Why do you apply the one-year bar rule when you dismissed it? It did not reach the Committee on Justice, or there was no prejudice to the person being impeached because it was dismissed. He doesn't have to defend himself. There is no, the reason for the one-year bar rule is you are not supposed to be subjected to multiple impeachments. But here there is zero impeachment because it was dismissed. So the ground of the Supreme Court in voiding the articles of impeachment was primarily because there was no approval by the plenary. They said the articles were transmitted to the Senate even without plenary vote. And that's why, and the Supreme Court in their decision quoted an ABS-CBN report that there was no vote. But if you look at the records of the House, they voted actually.
Yes.
There was a motion, and the presiding officer said, "Do I hear any objection?" There was no objection. So it's now the ABS-CBN report versus the records of the House. Was there a vote of the plenary? The ABS-CBN report quoted as authority by the Supreme Court says there was no vote, but the records show, and in fact, 2 hours later, they sent the articles of impeachment to the Senate. So that's why we're saying the first ground is totally wrong because the basis, the facts that they presumed to have happened were not correct, totally incorrect.
Well, what about the portion of the Supreme Court decision wherein it talked about the violation of due process. So this is
Well,
not just
this
the
is
one-year
not the
bar rule.
second.
But
The second.
the way that the Congress voted, it said there that there was not sufficient time for Congress to read.
Yeah, that's the second element. They
yes.
said that
To read the
another
articles of
ground, but
impeachment
we-
and the attached evidence, hindi daw na provide to the others.
Okay, the second are the additional requirements that he said. The House did not follow these additional requirements. They did not give the impeached officer an opportunity to be heard. No ex parte hearing. It has to be actual hearing. Okay, all those regulations that they said must have been complied with was adopted only now. It could not have been complied with by the House because they were non-existent at that time.
It was not a doctrine at that
No,
time.
it's not a nobody promulgated that. It's not in the House rules. It's not in any jurisprudence because this is a new jurisprudence.
Yeah.
So the question is, for an act that you did 1 year ago, you complied with all the laws, rules at that time, will your act be declared void now because you did not comply with this new rule that was adopted 1 year later?
Yun the doctrine of operative fact.
And that is violation of due process
Yeah.
because basic in due process is
Yes.
before you can be penalized, there must be a law.
Yeah, no retroactive application.
Yeah. There must be a law at the time you committed the crime. It must have been prohibited by law at the time you committed the act. At the time they committed the act, there was no requirement that they have to conduct a hearing, you have to give notice, because those due process rights were at the second level, either at the Committee on Justice or in the Senate.
Can we also argue, Justice, that now that we're talking again, going back to due process, that, okay, fine, a Bill of Rights provide for due process, but when you look at the greater scheme of things, and we're talking about accountability under Article 11 of the Constitution, wouldn't this somehow, the notion of due process, take a back seat to the prime objective to making sure that accountable officials are held accountable? Because due process usually, as defined, deprivation of life, liberty, or property without due process of law. In an impeachment case, an ongoing impeachment case like this, and at that time, at that phase of the impeachment proceedings, an impeachable officer is undergoing those proceedings. Is there already a deprivation of life, liberty, or property at that time?
Wala pa, because by comparison here, is that you file a case against somebody in the prosecutor's office, that complaint goes to the chief prosecutor, he reads it, and he said, oh, this is okay, I will refer this. So at that point, before the office of the chief prosecutor, nobody is given a notice. The one being complained of, the accused, is not being given a notice. Once the complaint or complaint by the private person is sent to the investigating prosecutor, that's when they notify. Because you cannot notify right away. The due process doesn't mean that the moment there's a complaint filed, you have to notify right away, even before the government official has acted on it.
So in this case, Justice Carpio, what would have been the correct procedure?
The correct procedure is what happened in the past. You file an impeachment complaint, it is endorsed by a member of the House, the plenary will vote, okay, let's refer this to the Committee on Justice for investigation and hearing. And that is the hearing, because the plenary does not hear.
Yeah.
Because it's so huge.
Yeah.
They have to create these committees unless they declare it a committee of the whole. And they don't declare that. So that is still due process because you are given your opportunity to be heard there. You cannot demand the opportunity to be heard at right after the complaint is filed.
You know, partner, before we take a commercial break, I think you'll be taking one soon. Very quickly, for whatever it's worth, I'm just curious what you would answer to this. Do you think that the Supreme Court decision has somehow vindicated our good friend, Senate President Jesus Cordero, when he took time? Because he was vilified by social media and in the traditional media about his inaction. Do you think that this Supreme Court decision somehow vindicated him?
Yeah, but before Justice Tony Carpio answers that question, let's take a short break.
Okay.
We'll continue our conversation with Justice Antonio Carpio as we weigh legal principles against political realities. Stay with us. This is Abogado.
Welcome back. You are watching Abogado. Before the break, Justice Carpio helped us dissect the constitutional dimensions of the Supreme Court's ruling. And we also asked him very quickly on do you think Senate President Jesus Cordero, who is a friend, was vindicated?
Well, the issue of forthwith is separate
Okay.
because here what the court is saying, the articles of impeachment that was signed by or verified and signed by 2015 was not voted upon by the plenary. That's why it's void. The issue is different when it reaches the Senate. Trial shall proceed forthwith. Iba yung issue na yon. That presumes that it was valid. Cheese never raised the issue of that the articles of impeachment are void. So
But
it's a different issue.
But Justice
see.
Tony, he did require Congress to certify that they did not
Yeah.
violate the one-year bar rule.
Yeah, and it
What
was
would have been
given.
the effect of that? Kasi, yeah, so ngayon, di ba, nag-certify na yung Congress. Pero yung Supreme Court decision said that
Yes.
Congress did violate the one-year bar
Yeah.
rule. So ano yung value ng
Well,
certification na yun?
Well, the certification will show that the House from the very start has said that our records here show that there was a voting. But the decision says you did not vote. So it's a question, factual issue. Did the House vote on the articles of impeachment to be transmitted to the Senate? You look at the records, they did vote. But the Supreme Court decision, citing an ABS-CBN report, you can see that in the footnote, there was no vote of the plenary. The plenary, even without a vote of the plenary, it was transmitted. So it's a factual issue.
But
So
Justice-
if the House did not vote, then the Supreme Court is correct. But if the House voted, the Supreme Court is wrong.
So who
It's
will,
as simple as that.
Who will determine that matter? Because
Well,
the Supreme Court is not
that's
a
why there
trier
will
of
be
facts.
no, there will be well, these are public records.
So they can take judicial notice.
Yeah, they can take judicial notice. I mean, the House already submitted this to the Senate, certified true copy of their proceedings. Journal of the House, that's official record.
Yes.
And if they want testimony, all the congressmen present there will affirm that. I mean, I don't think that can be questioned. So it's now the problem of the Supreme Court. They said in their decision there was no voting. The record showed there was voting. So what will happen now?
Yeah. What about, Justice, yung issue on Congress, members of Congress that voted, that were not able to read the articles of impeachment in its whole or to deliberate upon it, and also not having seen the attachments or any evidence attached to it. So, let's say merong umami na congressman na hindi niya talaga nabasa. Would that affect the due
They
process
signed a
requirement?
verification under oath that they have read it, and the allegations are true of their personal knowledge or based on authentic records. That is the only requirement in the court of law. That's the verification. So now you mean to say there will be a congressman say, I lied under oath?
Perjury siya.
Perjury siya.
So ang mangyayari dito, Justice.
But let's be there is already a verification
Yes.
under oath
Yes.
Yeah.
before the Secretary General of the House. Why will you say, binasa mo ba talaga?
Oo. But let's say, kunwari nga, napatunayan that someone lied and they
Well,
really didn't
that's
read it.
speculative. I don't think
Yeah.
that will happen, and nobody has come out.
But it doesn't affect the, or would you
Well,
say even theoretically it can affect the
No, there are many cases
validity?
where somebody who submitted an affidavit or stated under oath disowned it later, and the court said, no, we will not. The court still believed on the.
We've seen that in many criminal
So
cases.
it's
diba?
something that
May
can
criminal
be
cases na
overcome.
nagre-retract,
in terms of
nagre-retract, oh.
that type of...
Retraction is not favored.
But moving forward, Justice, so magpa-file for sure. They already announced, no? The House already announced that they'll be filing a motion for recon. And then, of course, I think we already discussed what would be the possible grounds. I think we elucidated very clearly kung ano yung mga pwedeng grounds na gagamitin ng House of Representatives as represented by the Office of the Solicitor General sa motion for recon. And legally, as a lawyer, my view is quite strong. Pero what are the possibility or the odds of 13-0 reversing themselves? We all know that it is very hard for Supreme Court decisions, especially if it's almost unanimous, to reverse themselves. So, one, the possibility of reversing itself. Number two, if I may jump to the next question, which is essentially the Senate will meet on August 6 rather, and they will vote on whether or not to proceed with the impeachment trial. So, two questions. How will that Senate decision to proceed or not proceed, considering that there is still a motion for recon pending in the Supreme Court, and chances are that the Supreme Court will not reverse itself?
Well, first of all, I will not say that we are certain that the Supreme Court will not reverse itself, because this is a situation where it's either black or white, because it's very clear. The Supreme Court has taken a position. You, Congress, did not vote at the plenary level, therefore, what you did was unconstitutional. Congress presents the House records. 300 congressmen will testify. Yes, we voted. So how will the Supreme Court decide? I think the Supreme Court will decide it correctly by saying, okay, that's valid. The first complaint is valid. The fourth complaint is valid. Because there's no other way.
What about the one-year bar rule? Because that's an interpretation issue.
Well, the one-year bar rule will be immaterial if they say that the fourth complaint is valid. Because,
Even if,
because if it's valid, then the one-year bar rule will apply, because you cannot harass him twice.
Yeah. Yeah.
So, that's why I'm saying, it's very simple. Totoo ba na hindi sila bumoto at the plenary or hindi? Because if the Supreme Court will say, oh, totoo, binoto niyo, pero unconstitutional pa rin. Anong ground ngayon? They have to cite a ground. Because the Constitution says you must state the ground for you must state the facts and the law of your decision. So what will be the facts that will they say? They will say that there was a vote, but we still declare it unconstitutional. It doesn't follow.
I guess like for me, the one thing I'm thinking about is the one-year bar rule is separate from the voting, wherein they're saying that
they're connected, because if there was a voting, then the fourth complaint is valid, and therefore it's valid. You must protect the person being impeached from additional harassment of future additional cases.
what about the first three? That I think that for me, what they're saying is that the fourth impeachment complaint violated the one-year bar rule because the three complaints were deemed initiated when it was dismissed.
The Supreme Court said it was initiated, deemed initiated when adjourned.
When adjourned, exactly.
But
So-
before the adjournment, they already approved the fourth complaint. That's why it's very important. Did the plenary approve the fourth complaint at all? They approved it. And of course, they approved it before adjournment. How could they approve it after adjournment?
Well, I'm going to ask a political question, Justice Tony. In this case, did the Senate, as an impeachment court or under Senate President Chis Escudero, also avoid what we call a constitutional crisis? Because can you imagine if the trial proceeded forthwith, as others argued, and then lumabas nga itong Supreme Court decision, what would happen to the trial that already started?
Well, they just stop it.
So that could have been a scenario.
Yeah, that
And
could have
they
been a
just stop
scenario.
it and
Yeah.
nobody will complain because if that is the decision of the Supreme Court. But now there is a pending MR. And the problem is this. The Supreme Court based its decision on the supposed fact that the plenary did not vote on the fourth complaint. The House is presenting the records. And all those who voted will testify under oath. Yes, we voted. And they have the video.
Well,
I think
I
it cannot be
suppose
denied
Yeah.
that they voted. I mean, that has to be accepted as a fact. They have the video.
Well, this is another theoretical question because this was also some of the allegations out there even before the Supreme Court decision came out. And it was not tackled in the Supreme Court decision. But some were alleging that money was offered to members of Congress to sign the articles of impeachment.
I don't know about that.
Yeah, so let's say this is a theoretical question. So let's say if that became an issue, does it affect the validity of the impeachment
Well,
complaint?
first of all, nobody has brought that up.
Yeah.
And I don't want to speculate on that.
Well, that was also the same thing that happened, if I recall correctly, Partner. You were part of the impeachment hearings against then Chief Justice Corona.
Yes.
I recall that there was a strong rumor that
Not just a strong rumor. One of the defense lawyers held a
Yeah.
press conference
Yes.
saying that they heard unreliable information, that money
Yeah.
was offered and
To-
given to,
Yeah.
promised to
You know, a lot of
members
people
of
will
Senate.
say, I have reliable information, but we have to deal
Yeah,
with facts.
but then
Yes.
a year and a half later, some of the senator judges, two of them, delivered a privileged speech saying that they were given
I think
money.
PDAF or something.
Yeah, to around 150 million, from what I recall, to
Well-
vote to convict. So,
Well, I guess that's
But
part of
that
the
time-
political.
yeah, that's why
Maybe
it's a political
I guess
exercise.
that's,
Yeah, but
that's political.
does that
But,
allow
yeah.
a mistrial in that case?
It's hard to prove. I would think
Oo.
if ever,
Pag
it would be
umamin
hard to
na.
prove.
Pag umamin na. So I
Yeah.
guess that was my question here. Kung,
Yeah, but it's speculative. I mean, I don't want to answer the too speculative a question.
Justice, the Supreme Court justices are also impeachable officers, as provided for in the Constitution.
That's right.
Now, would it be something that to ponder on, that when they came up with this ruling, it will actually also make it very difficult to impeach a sitting Supreme Court justice?
That's exactly the point of Justice Ascuna in his blog today, in his statement today, that the Supreme Court should refrain from imposing conditions that would seem to benefit them when they are the subject of impeachment. And besides, the Constitution says the House shall promulgate its rules to carry effectively this impeachment clause. No? So the Constitution committed it to the House. Kayong gagawa ng rules. And I don't think it's proper for the Supreme Court, ito yung rules ha, ito yung suggestion namin, gawin ninyo yan. And they are impeachable officers. So let the House do it.
Because you'll be like the judge and the jury and the
Yeah.
accused at the same time.
That's really the point of the Justice
I see.
Ascuna. And I think we should exercise judicial restraint by not saying, na ito yun ha, ito yun ha.
I see.
So to your point, Justice Tony, to what extent can the Supreme Court rule upon this as a legal question, and hanggang saan lang yung pwede nilang
No,
sabihin
the first
dapat?
thing is, was there a violation of the Constitution when the articles of impeachment was adopted? Yun lang. Ang sabi ng Supreme Court, they complied with the 10 session days, but they did not vote. That is the only error attributed by the Supreme Court. The Supreme Court did not say it was the person being impeached was should have been given this opportunity or that. The basic decision is you did not approve it at the plenary. That's why that article of impeachment is void. There must be an approval.
Well,
Okay,
thank you so much.
My
We're
last
running-
question, the
one
fearless
more-
forecast,
okay,
with
one
a
more
yes
question.
or no.
Yeah.
What's your fearless forecast, Justice Tony? Mare-reverse ba yung Supreme Court decision on an MR? Just, this is your opinion solely.
Well, the Supreme Court can always say, okay, the records of the House show that they did not violate the 10 session day rule. They adopted it. Okay, the articles of impeachment are valid, but from here on, these are the rules. They will impose the rules. So the rules will still be there prospectively. That is now the theory of Justice Ascuda, that they have to apply it prospectively.
Okay, thank you so much,
Thank you.
Justice
Thank you
Tony
so
Carpio.
much.
You know, partner, ang haba nung Supreme Court decision. Pinagtsagaan ko siya, 97
Yeah,
pages.
I
But
know.
having Justice Tony here
It
really
did really
helps break
clarified
down, and
a
especially
lot of
for
things,
the
and
public.
especially sa ating mga nanonood. Pero before we go, partner, gusto ko na siguro i-share din sa nanonood sa atin. No? Alam mo, bumabalik ako sa nung panahon ng impeachment ni President Estrada. And sa panahon ng impeachment ni President Estrada, ang bilis talagang nangyari doon. Siguro kung meron lang nag-file ng kaso sa Supreme Court, baka na-delay pa rin yun. I don't know. Hypothetically. Because doon, binasa, there were one-third at that time, it went to the House, it was transmitted to the Senate, nobody questioned it in the Supreme Court.
I will add to that.
Yeah.
If the Supreme Court will say that these are the rules, there must be, at the plenary, there must be opportunity for the person being impeached to be heard, not ex parte.
Yes.
There must be an actual presentation of evidence there. Then the impeachment of former President Estrada, the impeachment of former CJ Corona are
yes.
all void.
Correct.
Because that never happened.
Correct.
Interesting.
Correct. That's an
Oo
interest.
nga.
That's why it kept on.
Oo.
If only
And nandito
somebody.
pa naman yung dalawang nasa defense of
President
former
Estrada.
President
Yeah.
Erap
Yes.
and me for
Yeah.
former Chief
So-
Justice Corona.
so-
That's why relevant
So
yung mga questioning.
if they approve that, then you can file a motion.
Wala. Nako, namatay na po yung kliyente. But thank you so much, Justice Tony. We hope to have you back again when we have
Sure,
other
sure.
issues that are
Anytime.
relevant to you. Retired Supreme Court Senior Associate Justice Antonio Carpio lent his insights to these critical discussions. And your voice continues to shape the discourse on democratic governance. So thank you again.
Thank you.
Tonight's episode reminds us that even our highest institutions are not beyond scrutiny, and should it be? And that interpreting the Constitution is as much a responsibility as it is a power.
Here on our show, we strive to keep that conversation grounded, open, and informed. This is Abogado. Good night.